Well, across the region this week, there was surprise among some as former Barbadian government minister Donville Inniss was found guilty of 3 criminal counts when he appeared in a federal district court in New York on Thursday. Inniss was found guilty of 2 counts of money laundering and 1 count of conspiracy to commit money laundering. The unanimous verdict was handed down by a 12-member jury after just under 2 hours of deliberation. The court found that the former lawmaker took bribes from insurance giant ICBL in 2015 and 2016, while he was Minister of Industry, International Business, Commerce and Small Business Development. ICBL then paid him US $36,000 to use his authority to ensure that the firm's $1 million contract to the state-owned Barbados Industrial Development Corporation was renewed. The court was told that he then conspired to hide the payment by having the money sent to a New York dental company, then deposited into his bank account through a series of transfers. He is to remain on bail pending sentencing next month. Well, some commentators have suggested that Inniss's actions were far from the norm, were quite the norm in the region, with the idea of taking a kickback regarded as almost standard in this business, but they argued that he was foolish to do so in the US. General Secretary of the Democratic Labour Party DLP, Gyson Mayers, argued that if Inniss's trial had taken place in Barbados, the charges would have been tossed out a long time ago. DLP President Verla de Pieza, meanwhile, said that the outcome of the case should serve as a warning for public figures. She said it should be a cautionary tale for all politicians, persons in public life, and corporate entities. So, do U.S. courts really look at bribery differently to courts in the region? What are the consequences of the U.S. justice system reaching its arm into our region and into our politics? Well, joining us to discuss this and more, we have with us today a member of the Integrity Group of Barbados and speaker with expertise in auditing, risk and controls assessments, ethics and good governance, Krystle Howell. Good afternoon.
Good afternoon.
We also have with us today Attorney Ralph Bowen. Good afternoon.
Good afternoon, Rory. Good afternoon to your listening audience and my fellow panelists.
And with us also is former Attorney General of Dominica, Bernard Wiltshire. Good afternoon.
Good afternoon, Rory. And good afternoon to your listeners.
Krystle, let's start with you. What are your reflections on the significance of this case, not just for Barbados, but for us in the region?
Well,
Sorry, this is the question to Krystle here.
Hi, good afternoon to everyone once again. I echo the sentiment that it is a shock for our country. Obviously, we're sad that this had to happen outside of the country, but it is a warning to not only Barbados but the region, because we have very similar legislation when it comes to money laundering. The proceeds and the actions that would occurred, because he's a politically exposed person, he would have been considered automatically a higher risk than the average person. Therefore, more scrutiny should have been taken place where these transactions occur. And whereas there are many companies that would be investigating these transactions with heavier scrutiny, the problem always comes when you report, if you have a suspicious transaction, you report it to the correct authorities, whether it be the Financial Services Regulatory Commission, the Financial Intelligence Unit in Barbados, whichever regulatory body is related to the particular territory. You report these transactions, and then what happens? And the reality is that if this had been identified in Barbados or any of the other smaller territories, it is unlikely it would have gotten to the point where, as in the U.S., it went all the way to a guilty verdict. And that is unfortunate because it gives the impression that we're not as serious about addressing these matters as another territory or another country may be. But they do have a very real impact on us. And as we dive more into the money laundering legislation and the actions that should have been taken on either side, we'll be able to unravel where we may have gone wrong and how we can move forward as a region, because I don't think this is a problem that can be resolved by one country, but this is a regional problem.
Mr. Wiltshire, looking at Gyson Mayer's comments, that he felt that if it was in Barbados, the case would have been thrown out the charges would have been thrown out a long time ago. Does the U.S. justice system interpret bribery different to us in the Caribbean?
Well, I don't know. I don't know enough of the details of the case to say whether the Barbadian view is right or wrong. All I can say is that money laundering, since the beginning of this century, since the 1990s, mid 1990s and 2000, the Americans and the OECD more or less compelled us to put in place legislation and rules to prevent money laundering. And we all had to go through this. They insisted that they were going to put us on some kind of banned list. And we were going to lose corresponding bank facilities with American banks if we didn't comply, and so we complied. So our lawyers.
Mr. Wiltshire?
The Barbadian view is right, but I do agree with the previous speaker that it's a regional problem. There's a whole heap of corruption in the region. We don't appear to be able to take care of it in the region ourselves, and so it may be that the Americans, despite all the other things that are wrong with them, they may be doing us a favor.
Ralph, in this case, he was charged. I think the actual charges were money laundering, but essentially it surrounded a case of kickbacks. What do you make of the fact that this Barbadian minister was charged in the U.S., but he wasn't charged in Barbados?
Well, I think that speaks, Rory, to what the two previous panelists said concerning a willingness and intent to prosecute examples of what would be bribery in the Caribbean, whether or not we have the intent as the prosecutorial arm of the various government to root out bribery, to root out corruption, or whether we just accept that as a way of life in the Caribbean. I would hope, in that response to your earlier question, whether the U.S. looks at bribery differently than we do in the Caribbean, that is not the case. The fact is we have to hold our political leaders, the persons who are acting in official capacity, to a much higher standard in ensuring that they are utilizing best practices when they're dealing on our behalf with foreigners or even within the region or locally. So I would hope that there's no distinction as to how we look at it, and truly it may shed light on the fact that more investigations need to take place and more prosecutions need to take place in this arena. But it is interesting, Rory, just reading quickly around this article as you sent it to me just a day or so ago, that this case may have originated with an investigation of the company. And then it is in the conduct of that investigation of the company that these payments may have been found to have taken place, and then the charges were levied against the former minister. But there's something in the U.S. called the Foreign Corrupt Practices Act. It's something that the U.S. takes very, very seriously because it is designed to ensure accounting transparency and compliance with the Securities and Exchange Act of 1934 by U.S. individuals and corporations. And it also prohibits and punishes firms for paying bribes in order to get business advantages anywhere in the world. And I believe it is out of that investigation of ICBL that these payments were discovered and the prosecution took place.
Ralph, do you think the U.S. justice system is overstepping its bounds to kind of interfere with our regional politics?
No, because I don't think this has anything to do with politics. There was a crime here that was the gentleman was accused to have committed, that being accepting bribes in his official capacity, and he was also prosecuted for violating the U.S. money laundering statutes. Obviously, they would have had to lay out a case where the elements of the U.S. money laundering statutes would have been violated by this gentleman, Mr. Inniss, and they had the necessary jurisdiction to prosecute the case, both the subject matter jurisdiction, that being their law that was violated, as well as the personal jurisdiction over Mr. Inniss. I believe the article mentioned that he was a U.S. resident. So I don't see this as political interference. I see this as an issue of a law, a criminal statute being violated, and the necessary elements were met to substantiate the prosecution. And obviously they were met because he was convicted.
Krystle, do you think that Inniss was acting outside of the norms of regional politics? I mean, in other words, is there merit in the view that people put forward that, hey, look, this is normal, and it just so happened that because this involved a U.S. transaction, that he has been held to a different standard than typically would happen?
It is unfortunate that is the perception, because perception often becomes reality for many persons. But Barbados does have legislation that prohibits this type of behavior, and as the Minister of Commerce, Industry, he would have been fully aware of this legislation and the consequences that exist. There is a $2 million fine and the possibility of imprisonment if you are convicted of money laundering. And there's several legislation which, if he would have been processed under any of these, including theft or the same Prevention of Corruption bill, even though it's antiquated, he could have been charged under one of these offenses or under one of these acts if there was the political will to be able to do so. The problem is not necessarily legislation, even though it is antiquated and dated and requires a revamp, which Barbados is in the process of doing. And we're hoping that this particular case...
Krystle, let me just stop you there, because you talk about if there was a political will to charge him, but I mean, political will shouldn't have anything to do with charging somebody for a crime, shouldn't it? Because at the end of the day, the politicians should not be involved with the justice system.
In theory, it should not. In theory, the law, if it is broken, the person should be charged based on the facts that are presented in the case. But we live in the Caribbean, and if we keep going on theory, this is what's going to stop us from being able to move forward, because theory does not always meet practice. And if we're being practical, because of the small microcosms that we live in, where persons are connected, persons have friends in high places, and persons have positions which they abuse the powers that they have, the reality does not always occur. And if we don't face that and say that out loud, because a lot of persons don't like to say out loud because you're afraid of the backlash, you're afraid of what people will say, you're afraid of everything else, but we've been ignoring it, and then the reality of it has festered into what we have right now, where persons are saying that under Barbados jurisdictions or legislations, he will not have even been prosecuted, when that is not even the case. He should have been. But I personally believe that the will to have pushed it and to move it forward is not there. There are persons within the process that should have reported it as a suspicious transaction. If that was done, the Financial Investigations Unit should have investigated it, and if they deemed that it truly was a suspicious transaction that was worthy of criminal proceedings, it should have been put forward to the police or to the Director of Public Prosecutions. Why did that not happen? Especially when you read the facts of the case and everything laid out, at the very least, because the legislature says based on suspicion, not proof or evidence. You just have to be suspicious that there's a transaction going on that involves money laundering. Why did it not go forward? Why did we not properly investigate it? And if this is the case where we're saying that it would not have gone any further, that at the very least you can clearly see that something really wrong happened, what is to stop us from imagining that it's not more widespread? And if that happens and we give persons the impression that we are comfortable with this being seen as okay, when the rest of the world is telling us that it is not, it really puts a damper on our reputation as a country that's supposed to stand high above others in terms of ethical standing, good governance, and having a serious outlook on preventing corruption and bad practices.
Mr. Wiltshire, do you see these sort of kickbacks or alleged kickbacks here as something it's really just a one-off case with this minister, or is this something that costs our region quite a lot?
One-off? It's a way of life in the Caribbean at the moment. Kickbacks are a way of life. Corruption is a way of life in the Caribbean. Political corruption is a way of life in the Caribbean. We have a set of Caribbean leaders who are totally unworthy. You recall the other day there was an Al Jazeera program Al Jazeera station, which in fact documented the corruption, the extent of the corruption that is going on throughout the region. And what I'm saying is that, I mean, we here in Dominica, we've been complaining about this for years. We have, we're missing $1.2 billion, $1.2 billion in a little place like Dominica, which the government cannot account for. You understand? And kickbacks are a regular occurrence in the Caribbean. And it is a fortunate thing. I'm very glad that the Americans are there. I mean, as I said, there are lots of things wrong with the Americans, certainly with the kind of leadership they have at the moment, in any case. But I'm very glad that the Americans are there as a kind of backstop to punish wrongdoing and illegality when we in the Caribbean cannot do it. And we cannot do it in the Caribbean because we are very small jurisdictions, and as your previous speaker said, everybody knows everybody else, and the political public, the electorate is not particularly strong, certainly in certain islands like Dominica, is not strong enough to hold these people to account. Our institutions have all been undermined, and it is extremely important that somehow we get a grip on this corruption issue, which is stifling the entire Caribbean and stifling the prospect of lots and lots of people in the Caribbean, especially young people, who have absolutely no chance of seeing any future for themselves because the funds, the money that is being made in the Caribbean is being hived off and siphoned off by a few corrupt leaders.
Ralph, what do you see as the lessons for the region coming out of this?
Well, I just want to echo everything that the two previous panelists have said. The lessons really, Rory, is that if you run afoul of the U.S. money laundering statute and you fall within their jurisdiction, particularly where they could get their hands on you, whether traveling through the United States or if the infringement is significant enough that they feel the need to seek extradition processes against that individual, that they're going to find you and they're going to grab you. What the previous caller said insofar as this systemic corruption that exists, to me it is a process whereby it's part of how we function, and that is most unfortunate. It's most unfortunate what I don't remember his title, but the individual from Barbados who spoke about whether or not that minister or former minister would have been prosecuted in Barbados is most unfortunate. I believe there's been some effort to harmonize the money laundering statutes throughout the region, perhaps maybe pushed by the United States as well as Europe, to make sure that there is this understanding that money laundering is not acceptable and that you will be prosecuted for the same acts whether you're in the United States or in the Caribbean. I scanned the Antigua money laundering statute. It seems to be a very strong statute in terms of what's written on the paper. Enforceability or willingness to enforce is a completely different issue, and we have to move away from this idea that somehow that we will not do the right thing because of the actors who are involved. As a people, we have to recognize that these things affect us all. It affects us all throughout the Caribbean insofar as the type of investors we attract, insofar as the fact that our resources are not utilized for the best interest of the wider community, but rather for a select few. And if we continue to allow politicians and public officials to act in this corrupt way with impunity, then if nothing changes, then we are going to be the worse for it.
Krystle, what is it that we need to change about our political system then if we don't want to see these sort of kickbacks, or we don't want to see these sort of relationships, even if it is not kickbacks, where politicians are able to say enrich themselves with through close relationships with those who do business with the government?
Before I answer that question, I want to respond to the last comment, because that actually made me feel a bit sad, because if the thing that people may take away from this is not to launder money using anything through the U.S., but it does not mean that they're not going to try to do it outside of that jurisdiction where they think they might be better able to get away with it. And I don't want that to be the takeaway, that it's okay as long as you don't go through the U.S. or Canada or the UK, where they have much more strict laws or legislation or forms of investigation. We, unfortunately, will not be able to fix this by ourselves, any one country. That is my opinion, because of the relationship that exists. If we do not come together as a region, this will not change. These are things that have been happening for time immemorial, and it is so entrenched in our system that I sometimes wonder if people even realize that what they're doing is wrong. Even if it's in a textbook, and they see it in a textbook, and you have all the training, which is legislated, and that's not just in Barbados, in Antigua as well, and many of the Caribbean regions, the legislation is very similar, where you're required to train persons within different entities on how to recognize a suspicious transaction, what the red flags are, how to treat a politically exposed person. And even with all this education, we ignore the fact that if your boss tells you to do a particular transaction, which is what happened with the CFO for ITBL, based on her testimony, she said she was instructed to do so. And what happens when you receive these instructions from some person who is in a position to make your life a nightmare? The education does not always help you to know how to deal with this, and not recognizing that means that we're not putting things in place to counteract that. Our Attorney General, Dale Marshall, is imploring persons to come forward, but when we do that and we put the responsibility at persons, we're not recognizing the pressure that the person is going to be put under, the very real repercussions and intimidation that can happen when people decide that they're going to step out and they're going to testify against very powerful persons. If we do not recognize these, then we're going to put textbook solutions in place which will not work, because we're not recognizing the unique aspects of the Caribbean region that come into play to interrupt these things. We have to come together as a region so that persons outside of that reach In similar way to how it happened with the U.S., they're the ones who will be able to access this information without having those intimate relationships, without having as much pressure to be able to comply as someone else. We should not be submitting our suspicious transaction report to a local governance body that has directors or persons who may be influenced. I'm not saying this is what happened. I'm saying these are all possibilities of what could happen, and then be surprised that we as a region have not had anyone charged with money laundering, bribery, corruption, anything of the sort, because we are asking the persons who commit these crimes to police themselves. Because the reality is, many of the times when these things are going to happen, they're happening with persons who have power, who have influence. We have to step out of our individual countries, and we have to do this as a regional body.
Mr. Wiltshire, do you think the people in the Caribbean have more faith in the U.S. authorities than the regional authorities to tackle issues like this?
Well, they will. They will, of course, have more faith in the U.S. authorities, and the Caribbean people on a whole are very glad. But as I said, there is a backstop of the U.S. on that matter. And don't forget, the U.S. is not as beneficent to us as they should be. But on that matter, if our politicians know that at the end of the day, even if our police commissioners in the particular islands will not investigate or charge them with offenses while they're in office, they must know, and let all corrupt politicians quake in their boots to know that there is a power that can in fact hold them to account, even if the people of the region cannot. So I think that people of the region must be very happy that the Americans are in fact performing that role. And I think it isn't just the Minister of Barbados. I'm afraid this is not going to be the first one. There are lots more to come. Not just the Minister of Barbados. Lots more to come. And I hope the Americans will get even more active in helping us to put to control these criminals in high places.
Ralph, how far can the U.S. authorities go in pursuing cases like this in the region?
Well, as far as their laws and our laws in terms of the treaties allow, in terms of the personal jurisdiction, being able to grab people who may have committed. Rory, I don't want the takeaway to be from this that somehow in the Caribbean we are any more corrupt than, let's say, the people in the United States or in the United Kingdom. The fact is that the corruption, where it exists, there is criminal prosecution in these other jurisdictions. So there is a deterrent factor. The fact is that your corrupt practices will land you in jail in the United States, in the United Kingdom. So it is the fear of going to prison, the fear of that prosecution is what perhaps deter a lot of this corrupt and criminal activity, even by persons who may occupy offices of political offices or official offices. I have often remarked, Rory, that politicians are going to be as good or as bad as we allow them to be. In the Caribbean, we have allowed our politicians to be extremely bad by failing to prosecute their corrupt practices, by allowing them to treat us in a way as though they are kings and queens to rule over us, when all they are just public servants, chief public servants elected to do a job to represent our interests. But if we as a people do not insist on that representation, if we do not call, as the panelist from Barbados said, if there is no prosecution locally under the laws, if there is no protection for whistleblowers, people who would within the system would see these corrupt practices, if people are going to be afraid to speak out because of the victimization, then nothing will change. And then, as my colleague in Dominica says, then it is going to be up to these extra-regional jurisdictions to prosecute on our behalf that which we should be doing for ourselves, and that will continue to paint us as a corrupt jurisdiction because we fail to do the right thing. And as you know, Rory, I am part of Antiguans and Barbadians for Constitutional Reform and Education. I believe constitutional reform throughout the region is so vital to put into context that public officials are truly accountable to the people they represent at a constitutional level and ensure that these provisions are self-enforcing. Because when we allow this existing constitutional framework within which we operate to continue, we find that our politicians continue to just take advantage of what seems to be the unbridled power, the unrestricted power that the Constitution gives them, and they do not exercise that power or that responsibility with any honor.
Okay, we had some difficulties connecting earlier, but I want to say good afternoon to our panelist, Peter Wickham, political analyst Peter Wickham. Good afternoon.
Hey, good afternoon, Rory. Good to be with you.
Peter, let me put a question to you that I posed earlier, and that is, do you think that Donville Inniss was acting out of the norm of Caribbean politics here, and do you think he was hard done by?
Yeah, no, I mean, not at all. I wrote an article today in which I was commenting that the irony of it all is that Donville Inniss is doing something that everyone else does. I don't think that his behavior was out of character with the traditions in Caribbean politics, and it's an unfortunate reflection on our reality that this is the case. I have to say this. The sum of money involved was relatively small. I mean, it wasn't a huge amount. I mean, you've had far larger amounts of money dealing with in scandals in Antigua and Barbuda with medical benefit scheme and other things. So those are the parts of it which I think are hard. And then, I mean, if you look also at the individual's track record, I mean, he was actually one of the better MPs in the last government. I mean, it was a horrible government generally, but he stood out as being one of the few who actually opened his mouth and spoke. The mistake that Donville made was that he seemed to have conducted his businesses through an American bank, and as a result, he's run afoul of the law. There are suggestions that there are others involved in the same type of racket from his administration that conducted their businesses differently, and their names have not been called. The other thing is that he hasn't been charged in Barbados. He's faced no offense, and the General Secretary of the party has made bold to say that under Barbadian law, he's done nothing wrong. And I find that a shocking revelation from an institution that one would think should be concerned with making sure that, our laws are essentially up to par with the American laws. So it's hard for him, but I also think that there are important lessons that need to be learned. I'm not condoning what he does. I'm not condoning that type of action on anyone's part. But I think the signal to us is that we need to bring our own laws and our own practices up to par with, internationally recognized standards. And yeah, I mean, this type of thing needs to be discouraged. So, this is a start, and I hope that important lessons are learned from it.
Mr. Wiltshire, is it a matter of changing our laws, or is it a matter of using the laws that we have on our books?
No, we don't need to. Certainly for Dominica, I think it's the case for almost all the care. We don't need to change. We need to enforce the laws, and we need to do so. I think one speaker was saying about the quality of the individuals who are charged with administering and enforcing the laws. There's a big problem there, and we have a big problem there because in our region, the political directorate is top-heavy. All power is concentrated in the executive, and there's very little checks and balances. Very few, and even the courts are not an effective discourager for that kind of thing. The institution, all our institutions, the politics and the political executive has become so powerful. They have become too powerful. The power of the executive has increased, is increasing, and must be diminished. And a great deal of the corruption happens because there is no accountability. There's no one to hold them to account. Our parliaments cannot hold them to account because the parliaments are dominated by the executive. The courts cannot hold them to account, especially the OECS, for example, because the politicians have too much to do with the appointment of judges. You understand? So our institutions are undermined. The institutions that are charged, the police, the Integrity Commission. Look at what happened to the Integrity Commission in Dominica. The government of Dominica found the Integrity Commission was inconvenient because they were there, in fact, the Prime Minister himself for the court. So what they did, they changed the thing, mangled, distorted the whole thing, and then the result of what they put up said that there's no point in continuing the thing against them. So even when you set up an Integrity in Public Office Commission, we cannot even guarantee that that will work because the executive, a corrupt executive, can always find a way around it. So I have a hands up to the Americans if they can in fact help us to control these unruly and corrupt politicians we have in the Caribbean.
Ralph, is that...
It is not to say that the Americans are any better. I'm not saying that. I mean, it is a very corrupt country, we know that. But that is not what we're dealing with.
Ralph, is that simply the issue that our politicians are too powerful to be held to account by our justice system?
I think, Rory, that constitutional reform is the only way to address these issues for the Caribbean. I mean, the panelists from Dominica simply laid out. I mean, that was a roadmap as to the reasons why we need constitutional reform. There is no distinction between the executive and the legislature throughout the various Caribbean countries.
So you mean constitutional reform to weaken the power of the politicians, of the executive and the legislature?
To weaken the concentration of power in the executive. That you need to divest so much power, for example, from the office of the Prime Minister. And once you can decentralize the power and have greater contribution and participation from the people, then you would get the type of enforcement that we're talking about, because the idea of victimization by a very powerful few will then actually go away. And then you can also write into your constitution self-enforcing provisions that ensure greater accountability. You set up institutions that are separate and apart from the political directorate that will be in charge of enforcing these laws or enforcing the ethical practices of the people who hold official offices. That is what we need. But within the context where our constitution, which throughout the Caribbean was given to us by the British, and from a different political history than which we have or developed in the Caribbean, we need to start to draft constitutions or amend our constitutions that fit our particular circumstances. ABCRI is at the forefront of that in Antigua. I'm hoping that this effort would spread throughout the Caribbean. It's not a new phenomenon, but it's something that we need to do if we're going to seriously address the inadequacies and the dysfunctional aspect of our governments throughout the Caribbean.
Peter, I'm going to put it to you first and then ask Krystle for her take on the same question. That question of, are our politicians simply too powerful to be held to account by our justice system in the Caribbean?
I would say it's a combination of things. We have a challenge where we use a Westminster system in a very small environment, where the reality is that Parliament, for example, which is one of the main checks in the UK system, can exercise no independent authority in the Caribbean, because essentially all of the members of Parliament are usually on the government side are usually ministers. So that's one of the challenges that we have had over time. The other thing is that I don't know if I agree with a lot of the panelists that this thing is about the Constitution. I think it really is about our need to develop like whistleblower legislation, to give our Director of Public Prosecutions the opportunity to offer amnesty, as in the case with the Donville Inniss trial, and so on. And basically to modernize the system to allow for that level of investigation and checks and balances, and to allow people to be able to essentially keep an eye on the executive. The politicians are powerful largely because of the fact that they operate in these very small environments where we don't have the benefit of a robust media, we don't have the benefit of whistleblower legislation, and other ways and means of allowing civil servants, for example, to report on their superiors. But there's no reason why we can't do these things, and I think that that's part of it. We believe that we need a constitutional reform to do these things, but we don't. We just need legislation that will allow a person who is operating at the level of permanent secretary to raise questions about stuff that he or she is seeing, and to know that he can do that with the protection of the law when he is going forward to do so.
Krystle, your take on that question?
I also agree with Peter, because we have many instances where the law is there, everything is in place, and yet it is still not enforced. It is a very difficult situation because people are looking for a one correct answer, but it is a suite of things that would need to be implemented for these changes to occur. There's no one thing that would be able to fix a systemic problem that has been happening for decades upon decades, and it's not something that will be solved tomorrow either. But because the legislation definitely needs to be updated, because our 1929 legislation, when it comes to this, the penalties are inadequate. So even if that had to come to pass, a few $100 or $1,000 is not going to be a true deterrent to anyone engaging in any corrupt practices. And the reputational damage does not seem to always work once you are of a certain status in society. So I am strongly against making it seem as though there is one single thing that will help us to be able to reform. And I reiterate the need for a regional body to come together to address these situations. We do have the capability, but as I said before, practically speaking, even the same things that Peter would have spoken about with the whistleblower protection, practically speaking, in the Caribbean or in Barbados, for example, Antigua, we're all small territories where everybody knows everybody. What actual protection, what would that look like? And then we begin to understand why people are skeptical, even if that had to be in place, about using it. And in audit, that's what we do all the time. We try to see how it would look in reality, and then work backwards from there in terms of all the things that could go wrong once we put something in place. And once we analyze that, then working backwards. So if we put whistleblower protection in place, and we are not able to adequately protect persons from being victimized, and persons realize that people who have stepped forward have not been adequately protected, that pushes us further into persons being against stepping forward and keeping things to themselves and being afraid to step forward. So this is why I say we have to analyze the different solutions that have been put forward, take the pieces from them that will work for us, that we've analyzed, and get the process started, because I know that Barbados has a lot going on. There's a massive cleanup exercise that we are doing, and I do see areas that have been cleaned up, and I'm very grateful for that. But there are other areas, such as the integrity legislation, that has taken entirely too long to be implemented, which means it's going to take entirely too long for persons to be prosecuted. And these are still, even with this particular case, this is still a landmark area for the region where having or seeing persons prosecuted is not the norm. And technically speaking, the region itself hasn't even done it, where Barbados did not do this to Donville, the U.S. did it. So we still have a long ways to go, even if we did all of the reforms, even if we put all these things in place. in terms of action is where we always seem to fall down. And that is what I would like to see change so that we can be able to start taking these things seriously.
Okay, well, we have run out of time there, so I'm going to have to say thank you to all of you for joining us